Today we will have the opportunity to learn about progressive federalism, advocacy and strategy at the state and local level. For many of us, when we hear mention of federalism, an ugly history of states invoking laws to shield slavery and Jim Crow comes to mind. However, these days, states and local governments are more in tune with the interests of traditionally oppressed groups, including racially minorities who historically have had the most to fear from federalism. At this day and age, under this administration, change is coming from the bottom, locally, and not from the top. That's why today's panel is so important and timely. I am honored to be introducing our moderator for the panel, Professor Richard Schragger, who teaches local government law, urban law policy, as well as a number of other courses here at the University of Virginia School of Law. Professor Schragger's scholarship focuses on the intersection of constitutional law and local government law, federalism, urban policy, and the constitutional and economic statuses of cities. Please join me in welcoming Professor Richard Schragger.
Thank you. Thanks so much. This is a panel near and dear to my heart because I write about cities, and so we're going to do federalism all the way down on this panel. But we have a fabulous group today who are operating at this intersection of local and state, and then federal. I'm going to introduce them quickly, and then I'm going to let them speak about what they do and how they view particularly the state and local relationship to the federal government these days, and then we'll move into questions. So immediate on the far end is Ryan Park. He's the Deputy Solicitor General for the state of North Carolina, and he focuses on appellate and constitutional litigation. He was a Supreme Court clerk for Justices Ruth Bader Ginsburg and David Souter. That's a double. That's impressive. And he's a graduate of the Harvard Law School. Thanks for coming, Ryan. Next to him is Sylvia Albert. She's with the she's the national campaign manager of All Voting is Local. Perfect. And she got her start. She's worked at HUD. She got her start with the Obama or the Obama campaign with the Nevada. She was the Nevada Deputy Voter Protection Coordinator in 2008, and she's a graduate of Berkeley and the Georgetown University Law Center. Thanks for being with us. Next to her is Galina Varchena. She's the Policy and Communications Director for NARAL Virginia. And she leads NARAL's pro-choice General Assembly and local government policy work and fosters relationships with partner organizations and local communities. She's a graduate of the American University Washington College of Law and the American University School of International Service. To my left is Cami Chavis, got that right, Associate Professor for Academic Initiatives, Director of the Criminal Justice Program, and Professor of Law at Wake Forest University School of Law. She writes about police accountability and law enforcement issues. Her articles have appeared in many academic journals as well as in popular publications as well, like the New York Times and the Wall Street Journal. And she is a graduate of the University of North Carolina, Chapel Hill, which we won't hold against her at UVA, but also of the Harvard Law School. And then finally, but not least, is Trevor Cox. He's a counsel at Hunton, Andrews, Kurth, LLP, but he's a former acting Solicitor General of Virginia, and he had numerous roles in the Office of Attorney General in the Commonwealth. In addition to those, he also teaches a course on the Constitution and the State Attorney General at the University of Richmond School of Law, and he is also, it turns out, a Harvard Law School graduate. Too many of us up here. So I thought we would just begin with Ryan down there, and we'll just work our way across and speak for 5 or 10 minutes about what you do and how you see your work intersecting with this question of progressive policymaking and lawmaking at the state and local levels.
Sure, yeah. And Trevor and I kind of have overlapping, expertise and experience, and we'd kind of thought that it might make sense because Trevor actually spent longer in this role to kind of give an overview how state attorneys general work in this area, and then.
So you're phoning a friend? Is that what you're doing?
Exactly.
You're phoning a friend.
But I can do that as well if.
No, the moderator is overruled by the panel. So Trevor's going to start. Are you okay with that, though? You have to accept Ryan's pass.
Sure.
He's a good guy, he says. This is interstate comedy right here. Okay.
I like it when they phone a friend and the friend has no idea.
Has no idea. He's like, I don't know what Ryan's talking about, but here we go. Okay, so Trevor's going to start, and then we'll work it back this way, maybe. Okay, thanks, guys.
So as Professor Schragger mentioned, I was in the Attorney General's office here in Virginia for over 4 years, and I held a number of roles in the Solicitor General's division. For those of you who aren't familiar with the layout of Attorney General offices, most of them now have an SG role the way the federal government does. And the SG's office handles appellate matters, constitutional challenges to state statutes, and other high-profile or sensitive issues that the Attorney General may like handled in a certain way. So generally, the SG is a politically appointed role and is responsive to some of the more political needs in the office. So my perspective is based in that, but I want to emphasize, both on my behalf and probably Ryan's too, that that's a very narrow slice of what Attorney General offices do. So even though we're going to be talking about that in the context of this panel session, there's a huge amount of work that Attorney General offices do that is just not political in the way that we're going to be talking about it today. I mean, it's political in the sense that there's a political actor who's accountable at the end of the day. The Attorney General is popularly elected in, I think, 43 states. In other states, they're appointed by the governor or the legislature or the Supreme Court in Tennessee. So there is a political actor accountable, but it doesn't matter whether you're Republican or Democrat if there's a contract that needs to be negotiated for the state to lease space for state office building or to engage in eminent domain proceedings to build a highway. That kind of stuff is work that is handled by the Attorney General's office, and it's just not anywhere on the political spectrum. So just keep that in mind as we talk about that narrow slice of work that you see all over the newspapers, but you may not know occurs also across the office. So that's the place that I come from in the Attorney General's office, and it's a place that has become very public in recent years because AGs have taken on the mantle of leadership and pushing back on a lot of federal initiatives. And I thought it would be useful to talk for a few minutes about how that came to be, and is that the right way for progressives to proceed, and are there other groups that may push back on that in the coming years? So a brief overview of how that happened. We'll go back to the 1980s, which has Lieutenant Governor Habib pointed out was the era of Cyndi Lauper and Boy George. It was also the era of Ronald Reagan. It was a period of intense deregulation when Congress and the White House affirmatively pushed down regulatory authority to the states and gave them powers to enforce, especially in consumer protection areas and antitrust areas, gave them power to do that. The Federal Trade Commission cut its staff in half. And so left a lot of that to the states to do. The states had traditionally been not very active in a lot of areas. The state attorney general was an important but largely irrelevant figure in a lot of ways, and that was the first time that they really took on a lot of authority. Concomitant with that, they grew their staff sizes. They had budgets that increased 300% to 500% between 1980 and 1999, and they really started to see the value that they could play in solving larger problems. So in the 1990s, I think facilitated by a group called the National Association of Attorneys General, NAG, they started connecting more with each other, and technology even played a role in that. The advent of fax machines allowed them to communicate with one another and allowed them to bring to bear a collective force against corporations, largely, who maybe not have feared the threat of a lawsuit in one state, but once multiple states started talking to each other, they really were able to force corporations and bring them to their knees. And a good example of that is this tobacco litigation in the 1990s. They culminated in a settlement in 1998 with 46 states and the District of Columbia and Puerto Rico signing on to it against 5 major tobacco companies to the tune of over $200 billion, billion with a B. Big Tobacco had never lost a lawsuit, and yet they agreed to this settlement that continues to fund, frankly, a lot of good initiatives in the states. So that led to attorneys general bringing more collective actions against Microsoft and AOL and Publishers Clearinghouse, and that kind of consumer protection bent continues to this day. I think Ryan will talk a little bit more about that. But by the late 90s and early 2000s, you saw more of a rift starting with attorneys general becoming more political in nature. People are still members of NAG, but offshoot groups were formed. The Republican Attorneys General Association, RAGA, and the Democratic Attorneys General Association followed quickly. So RAGA and DAGA promoted this idea of Republican AGs on one side and Democratic AGs on another. You saw aspiring politicians see the role of the AG as more of a stepping stone to higher office, and so they became increasingly politically active, still focused on consumer protection type matters, but also seeing that they had a voice. John Ashcroft, when he was Attorney General in Missouri, he began to run for governor, and people noticed there's a huge number of cert petitions that started coming out of his office, where he saw that as an opportunity to showcase the things that he believed in. So by the, I guess, late 2000s, Obama era, you had a lot of attorneys general who were fully primed and ready to go. And all they needed was a foil. And so Obama came to office, and attorneys general sort of exploded onto the scene. They already had a mechanism for communicating with each other. They already had a shared political perspective, and they started deploying that in lawsuits that we all are familiar with, a variety of Obamacare lawsuits. And it got to the point that Greg Abbott, the Attorney General of Texas, when asked to describe a typical day, he says, I get up, I go to the office, I sue the federal government, and I go home. And there's some truth to that. I mean, I think during his tenure, he brought, I think, between 2 and 3 dozen suits. And so, we're familiar with that in the Obama era, and that continued in the Trump era. I mean, it's not just on the Republican side. Attorney General Becerra of California, he left his role in Congress to fill the AG role when Kamala Harris became a senator. So he left that national post to become a state attorney general, and he said, I'm going to be Trump's worst nightmare. And he has, just as Greg Abbott did on the Republican side, he's sort of filled that role on the Democratic side, filing dozens of lawsuits on behalf of California. So that's where we are. You can talk about whether it's a good thing or not, and whether AGs are the best profile of people to be bringing those suits, but it is a fact of life. I want to pass on, as we think about whether AGs are the best people to be carrying that mantle, a rubric that I think is useful that Paul Nolet at Marquette University, who studies AGs, has developed. He divides AG suits into 3 different buckets. One is policy blocking litigation, another is policy forcing litigation, and another is policy creating litigation. So we can think about the various lawsuits that Ryan will probably talk about, or that might come up elsewhere on this panel or elsewhere in the weekend. We can divide them into those 3 buckets. The policy blocking litigation is stuff like the travel ban. Let's stop Obamacare. This wall, national emergency, let's stop it. The government is doing something that it shouldn't be doing, let's stop it. The policy forcing litigation, as you might guess, is applicable in areas where the federal government is not doing something that it should be doing. We see this in the environmental space a lot, where the federal government is supposed to abide by certain standards or safeguard the environment or the public in various ways, and they're not doing it. And so you might bring suit to force them to do it. This happened even in the Reagan years, but then famously happened in thousands with Massachusetts versus EPA, where Massachusetts says, you're not following the standards that you said, and we're gonna take you to court to make you do it. Then policy creating litigation, tobacco settlement is a good example of that. Not only do the tobacco companies have to hand over huge amounts of money to states, but they also had to agree to certain settlement measures. That's why we don't see certain kinds of tobacco advertising. It's a result of that settlement with states, 20 years ago, not because of congressional litigation. And that was sort of a point of tension between Congress and federal executives and state executives at the time. You had people like John McCain referring to state AGs saying, who do these people think they are, that they would essentially create legislation? They're not legislators, but they're forcing tobacco companies to abide by these standards. That's our role, not the state attorneys general. You had William Pryor, who was then the Attorney General of Alabama, now on the 11th Circuit, saying that attorneys general and that kind of behavior was the greatest threat to law, the rule of law, which seems laughable now. But it was his perspective that this is not what AGs ought to be doing. And so the third point and final point I would make is, as we think about whether AGs should be the ones who are carrying this mantle of progressive litigation, there are a variety of other stakeholders who may think that they're not the right people to do it. Certainly state governors who maybe have a different political persuasion might think that, and so you can read about how, for instance, in the state of Maine, the governor would purport to bring suit on behalf of the state or to join, another Texas suit to block the ACA. And then the Attorney General saying, no, you don't get to speak for the state, I do. And so you get these interesting questions of who gets to determine the state's legal interests. Is it the Attorney General or the governor or somebody else? And that can vary by state depending on their constitution, depending on their statutes. But that's one relevant question that I think people are going to be grappling with in the coming years, is who gets to determine the state's legal interests. It's not just the governors that assert that power over AGs, it's also the legislatures too, who, if they're not constricted by their state constitution, could change statutes to make it more difficult for the state attorney general to decide what the state's legal interests are or determine what lawsuits get to be brought. The legislature might reasonably say, no, we get to do that, especially if what you're doing is usurping our power. So, I think in Georgia it was that they tried to impeach the attorney general for not joining an ACA suit. You see state legislatures trying to reduce the budgets of AG offices in order to compel them to act in a certain way. And you have legitimate legal questions about whether legislatures can act alongside state attorneys general in challenging government or in governmental action or in stopping AGs from doing what the AGs are trying to do. That's a version of that question is before the U.S. Supreme Court in a redistricting case that's going to be argued next month out of Virginia called Bethune-Hill, where the Attorney General decided not to appeal an adverse decision on behalf of the state, and yet state legislators who had intervened in the case say, no, we actually have a stake in this, and we get to appeal it. So I won't get into too much depth because probably a lot of people haven't taken federal courts, but the question is whether they have standing to raise the state's legal interests, whether that belongs to somebody else and who gets to decide. So that's something to be on the lookout for. Municipalities is another group. I know we're going to be talking more about that, but increasingly you see municipalities raising claims on behalf of their residents. And is it the state attorney general who gets to make those calls, especially when you have very large cities like San Francisco and New York purporting to bring claims on behalf of their residents? Who gets to decide? Who gets to call those shots? And you can imagine situations where municipal leadership is not in political agreement with state leadership. So that's a challenge, I think, that's going forward. But ultimately, as I look forward for the next couple years, state AGs have had to play a role by necessity because Congress has, whether by choice or just laziness or whatever, has not provided that check that is necessary. So that obviously is starting to change. So there may be less of a role for state AGs to play. And then finally, I think voters may well decide that we don't want our state AG doing these kinds of things. We are tired of the nationalization of state politics, and we want AGs to return to the role that traditionally they've played. So I think those are all dynamics that are at issue with state AGs, and hopefully that gives some good background for Ryan to add on with specifics.
Yeah, thanks, Trevor. So maybe we should go to Ryan. Do you want to add? And one thing, maybe Ryan, you could tell us is why you chose to go into state government as a career choice.
Yeah, sure. So first of all, I have to make a standard but necessary disclaimer. I'm speaking on behalf of myself, not my boss, Attorney General Josh Stein. But yeah, I mean, I think that's a good opening because after the election, I think I hadn't specifically thought I was going to go work for the Attorney General of North Carolina. I had wanted to move down there, but that wasn't necessarily the first thing that I had in mind. And it was kind of wrapped up in this national conversation and the role that attorneys general are playing nationally. And with everything that was happening, as a progressive lawyer who wanted to make a difference, I thought that was a really unique place to be, working for a new progressive attorney general in a purple state. And so that was a big part, not the only or maybe even the main, but that was a big part of why I was interested in getting involved. So I started along with a newly elected attorney general. And I think I guess I can talk a little bit about what is happening now and how it kind of intersects with some of the larger questions that Trevor mentioned. So, I think one concern that we all should have is that, this kind of federalism isn't necessarily progressive, right? And it's a function of what's going on in the world right now, that these kinds of lawsuits are that we all hear about every day when something happens where the federal administration does something that might be illegal, that a group of usually Democratic attorneys general come together and file a lawsuit. But even in this era, it's not only the Democratic attorneys general that are doing it, right? So the ACA lawsuit continues, where it continues to be a group of red states led by Texas that is challenging the constitutionality of the Affordable Care Act, and the Democratic attorneys general have intervened to defend the law because the federal government wouldn't, and so we actually have kind of a blue versus red lawsuit going down in the Fifth Circuit right now. And I think it's very exciting to be a part of that. And there are a lot of other places, a lot of other legal groups that are also a part of lawsuits like that. But when you are in one of these offices, you're a core player, and it's exciting. But you have to step back and think, is this necessarily good when the federal administration is one that you support? And if you can't come to those kinds of neutral principles, then you start to question whether the system as a whole is good. I guess my answer to that question, and again, speaking for myself, is it's kind of similar to the answer that you give for judicial review in the first place, right? Which is that you can believe in progressive federalism when it's rights enhancing, and that when there are kind of the famous footnote, right, the discrete insular minorities footnote, right, that when when this kind of litigation is used to take away rights and to harm disadvantaged groups further, then maybe it's not legitimate. But if when attorneys general come together to protect people, then it does have broader legitimacy. That's different than just politics through lawsuits. But I will say too that, and Trevor mentioned this, it's not necessarily political, and a lot of the work that you do on a multi-state basis, like the tobacco litigation and the modern precursor is this opioid litigation, is all states coming together, and it's this tobacco settlement, right? It's probably arguably the most effective tobacco regulation that the country has ever had, or regulatory apparatus is this multi-state red-blue joint lawsuit that was brought in settlement. I guess settlement is the better way to describe it. And currently that's playing out with opioids, we hope, where it's a bipartisan group, and there is a hope that we'll reach a point where we'll have an effective, regulatory apparatus through a group of attorneys general coming together and engaging on a bipartisan issue. So I guess I'll talk briefly about a couple lawsuits. Is that sure? Does that make sense? So there's, there's everything that's going on, and you're probably all familiar with a lot of what's going on. But I guess one thing that I'm working on now is on offshore drilling and the environmental impact off the coasts. And I think it's a good case study for how this can work well in kind of the blocking model that Trevor talked about. So the Trump administration is likely moving forward with plans to open up the entire Atlantic seaboard to seismic testing and then drilling off the shores. And this has a host of environmental and other impacts on the coastal communities and others. And so it's something where we've come together with most of the coastal states, including South Carolina, although they have filed kind of an adjoining lawsuit where it's similar claims, but they're not part of the group of others that are bringing the same claims, but it's Democrats. And so, all the suits are consolidated, and we're all coming together to try to stop the drilling off the coast. And it's a collaboration with a lot of environmental experts in the nonprofit sphere, with private law firms in DC who are adding a lot of legal muscle. And so it's something very, very exciting to be a part of. And you see a lot of different groups coming together to try to stop a policy we think is illegal.
Thanks, Ryan. So one thing it reminded me when you sort of said I went to the state, I wasn't really intending to. Progressive federalism is not new. Louis Brandeis famously said to his clerks, Supreme Court clerks who could go and do anything they wanted, he said, go back to your states, go back to your local communities and do your work there. And at that time, progressivism was not a viable option at the federal levels. And we forget that because of the history of the civil rights movement, which has been portrayed, and I think rightly so, as bringing recalcitrant states into line, states' rights being the bugaboo, obviously, of progressive civil rights agenda. But I think our longer history actually shows that the federal government and the central government and the Supreme Court in particular are not particularly amenable to progressive ends. And so, in fact, state attorneys general, and others have long been at the forefront of progressive efforts. And so one of the things that I think progressives need to remember is that agenda is, that arena is available, and two, that it might be actually more fruitful in the long term. What do you see, Sylvia, at All Voting is Local? What's going on there?
Sure. So I think probably on this panel I will be the most local of the guests. So I think I'd hope most people are aware the Shelby County decision, which eliminated pre-clearance from the VRA and took away a lot of the power of the federal government to inhibit states from enacting discriminatory or statutes that had a disparate impact on minority communities. So since then, as we look forward, the voting rights community has moved downward. So, and we're moving downward on two different fronts, which is a litigation front and an advocacy front. And depending on what level you're at, one will be more successful than the other. So what you have are, statewide cases regarding, strict voter IDs in the state. But then on top of that, you have redistricting cases. And then you have, on the advocacy side, you have I'm looking for the word, the petitions in the states, which have been successful in passing automatic voter registration, same-day registration, a very successful petition, which, was a state constitutional amendment, which just provided returning citizens in Florida their voting rights. So you have a variety of these things that can also be done at the state level in a combination of litigation and advocacy. And just like anything else, unfortunately, right, Shelby came from the Supreme Court. This Virginia case is going to the Supreme Court. A lot of these state cases will end up at the Supreme Court. And so we are also looking at other ways to be effective in protecting and expanding the electorate. So that is kind of where my team comes in. All voting is local. We are literally working from the ground up. And what that means is we are in local communities talking to city clerks. We're talking to county recorders. We're talking to, the people who actually affect election administration every single day. I think we often, as attorneys, we've all been guilty of looking at Supreme Court opinion and just going, oh my gosh, that was great. Now everything's fixed. Well, how many years after Brown were schools actually desegregated? And are schools still desegregated? No, not really. So, right, it's implementation that matters. And when you get down to it, that really is the local level. And in states where you have progressive statewide office, then you can go to the Secretary of State, or you could go to the legislature in your advocacy. And so you're working on different levels. You might be asking the legislator to pass a bill. If that's not going to happen, you're looking at gathering signatures. If that's not working, well, maybe the Secretary of State can direct all of the local election officials to do X. Or if you're in a large community, the Maricopa County Recorder, Adrian Fontes, that's Maricopa County, which is the largest area of Arizona. So having one-on-one interactions with him and talking to him about ways to expand the electorate, that actually is going to affect so many people. When pre-election, it was the Republican Secretary of State who was not open to expanding the electorate. So we work with a lot of partners, right? We are partners with ACLU, we're partners with NAA, we're partners with, all of the organizations, right? It's really a community that comes together. And I think what we are trying to get across is that litigation is not the only way, and especially in this climate where the courts are not being friendly and are being stacked with conservative judges and justices, we need to look to the people who are actually administering elections to make a big impact. So, for example, in Arizona, working with, there was, as you all know, because I know you all watch TV, when election was called in Arizona, some people were up, some people were down, but they had 250,000 ballots to count. Because of signature matching, some of these people were not going to be able to have their ballots counted. By working with the Secretary of State, we advocated that just like anybody who passed in their ballot before election, every citizen should have 5 days to cure their ballot, which means showing up to show ID and match a signature. Adrian Fontes, who is, and I use him as an example just because we've worked with him and he has a large community, he was amenable to that. We didn't necessarily go to the other counties in Arizona that we felt would not be amenable to that. It didn't, and it wasn't going to happen at the Secretary of State's level. But by doing that, that enabled, that gave these 250,000 people who dropped their ballot out on the last day 5 more days to cure their ballot. Now, of course, Republicans counties sued, asking for the court to stop it. The court basically said, oh no, what we'll do is make all counties follow this five-day rule, which works for us too. It wasn't like we were saying, hey, only Democratic counties do that. Probably not what the Republican administration or counties wanted. And in the end, everybody in Arizona was given 5 additional days to cure their ballot. So Whereas we were working on the local level with Mr. Fontes, and that happened by advocacy, when the Republican officials sued, our partners came in and intervened, ACLU, I believe, and maybe Lawyers Committee? I'm looking at Bobby because he would know. Lawyers Committee intervened. So we are talking about a advocacy and litigation strategy, and not just always going from top down, right? Going from bottom up at the local level, especially with election administration, can make a huge difference.
Yeah, so it's an incredibly important lesson. There are institutional features which you draw attention to of federalism, which we do not pay attention to. We just think states and national, but there's in fact state, national, local. And what's also quite important is that the states are often divided executives, right? So the Attorney General is independently elected from the governor. And so there's all this institutional space. And another great point, the Supreme Court isn't the end of anything. It has to be implemented at the county level, at the local government level, at the city level. And so there's lots of room there to have leverage for these kinds of things. So that's these institutional features which we don't pay enough attention to, I think, that allow you to do workarounds, right? Which I think is part of what you're talking about here. That's quite important. That's great. What do you see, Galina, in Virginia in an area that is so dominated by the Supreme Court, right? Choice, abortion rights. Can we get away from the Supreme Court, or is that not possible? Anyway.
Okay, well, we don't have a choice but to get away from the Supreme Court, because the Supreme Court is no longer favorable, and they have punted so far on making an out loud decision about abortion. The most recent case was the Louisiana Gee case, where the Supreme Court said we're going to uphold the temporary injunction on this bad Louisiana law that essentially mirrors the law that was overturned in the Women's Health case in Texas. But we're not going to issue any opinion except for Justice Kavanaugh's just obnoxious dissent. That reads very much like, well, this is just about procedure. No, it's not. He was like, I'm going to ignore precedent and ignore all of the evidence that was presented in the previous cases, and just... Anyway, if you want to read it, it's entertaining. But because we now have this Supreme Court, we know, and our opponents know on the other side, that Roe is, even if it's not going to go away outright, it will be chipped away to the point of being ineffectual as a protection for abortion rights nationally. And one has to say that Roe in and of itself was a promise that was never fulfilled for a lot of people. And the fact that abortion rights writ large, we all had them, but a lot of folks could not access them, and a lot of states have been hostile to abortion, and a lot of cases subsequent to Roe have chipped away. But now we expect that this chipping away will be a lot faster. So what's happening in Virginia? A lot is happening in Virginia. Virginia is currently on fire. If you have not watched the news, but that has not as much to do with abortion. But what is happening in Virginia is there's several lawsuits. There are lawsuits on the state level. So the Family Foundation funded a lawsuit against the Board of Health and VDH, because Board of Health and VDH at one point made positive changes to some regulations, the CHOP regulations, and did it in a way that the court currently deemed, we got an opinion, but we have not received a decision yet, deemed to not conform to the Virginia Administrative Procedures Act. We don't know what that will mean for abortion providers because we don't have a decision yet. And then there's also a lawsuit put forth by abortion providers that started before Kavanaugh, going against the Board of Health and VDH in the federal court, challenging a lot of the bad restrictions in Virginia. Virginia is one of the worst states in terms of abortion restrictions, even though we have a lot of abortion providers. Well, a lot, not sufficient and only in certain areas, but more than Louisiana, more than Mississippi, right? But we still have some really bad laws on the books. We have been working with the administration for now to make some positive changes. So we are redoing the trap regulations. The process is ongoing, so we are advocating on that level. We're also looking more closely at local governments. So far, the success has been on the other side, like Fairfax County passed some bad zoning regulations in there, and that essentially caused the loss of one of the clinics. That was in Fairfax because it's a little complicated. They created a new category for medical provider and then added in all of these requirements that the provider could not meet. But we're trying to work on the local level to see if we can get some buffer zones down, to see if we can get some regulations down that are more favorable to abortion providers, specifically zoning for medical facilities, to see if we can get rid of some of those local barriers. We're working on the state level, working with the administration, VDH, and Board of Health to try to figure out if we can loosen some of those trap regulations that are bad, and now maybe we'll have to redo the process. We don't know. And we are, at the end of the day, we're going to have to work on elections because we don't have a pro-choice majority in the House or the Senate in the state. And as we've seen year after year, no matter how popular a particular law is or a particular bill is, when you come up against the wall of a legislature that is not willing to entertain it, just look at what happened to the ERA most recently in Virginia. There's nothing you can do. Like, the governor can't just pass legislation. There's only so much that the administrative state can have an effect on. But turning back a little bit, last but not least, I think it's important to remember that while we're advocating through all of these legislative, administrative, legal realms, there's also the realm of trying to help folks who are working on the ground and actually working with the populations who need help the most. So, we work closely with the abortion funds to try to promote them and make sure that there's awareness that they are doing the work that's actually required to make sure that folks who need access can get that access. Because while, it's great to have a right, but if you can't access it, that right may as well not exist. And the one last thought, in 2010, according to the Guttmacher Institute, there were 10 states that were hostile or very hostile towards abortion. Today, that number is 21 states. And while there are positive movements in some states, there's a lot of bad out there. There's 6-week bans, 16-week bans, 18-week bans, 20-week bans, heartbeat laws, fetal pain laws, prohibitions that are rolling up through the states. So when we're thinking about protecting abortion in Virginia, we're not just thinking about protecting abortion in Virginia for Virginians. We're also thinking about the fact that should Roe be gutted or should Roe fall, there's not going to be access for abortion from Virginia all the way down to Florida and westwards through most of the states until Colorado. So that's our reality.
Local and state elections matter. That's where it's going to be, right? Local, because they can pass a zoning ordinance, right? Right? State, for obvious reasons. If Roe is struck down, then you might have a federal regime, right? And then the states are where all the action is. Incredibly important. What do you see, Cammie, on criminal justice?
Okay, so it's Saturday morning, and once a law professor, always a law professor. You guys are law students, so I have a question. Who's Rodney King? Somebody tell me, who is Rodney King? And I've got 4 Wake students out here, and I know all of their names, so don't make me call on them. Rodney King, yeah, you have to be close to calling somebody closer to my, come on, give me a hand. Yes. Yes.
An LA resident who was beat up by the police and it was caught on camera somehow, and resulted in the Rodney King riots in LA.
Exactly, right. So, and what does Rodney King have to do with progressive federalism? So let me just tell you a little bit about that. Before there was Freddie Gray, which a name that might be familiar to you. Before there was Tamir Rice, Philando Castile, and unfortunately countless other minority men who were who died or beaten in the custody of police officers. There was Rodney King. And so this happened in Los Angeles, early 1990s. And what we learned from that, the beating of Rodney King, he did not die, the beating of Rodney King was the Los Angeles Police Department, they had all of these racist communications that were coming through on their, then these little computers that they had in their cars. The police officers who beat him, there were 4 who actively took the baton swipes and the kicks and the things like that and caused the physical injuries. But there were about 50 other officers on site present who just stood and looked around and saw this happening. So when we see something like that, we have to ask, what's the culture? What's the culture like within the police department? There was, of course, the Christopher Commission report, which you may have heard about, but there were also some following that, some congressional investigations that said, look, these systemic problems that we're seeing in Los Angeles are happening nationwide. We can go to almost any major police department and find the same type of cultural or systemic organizational issues. So what did Congress do? There was no way for, at the time, any citizen who'd kind of seen this and was bothered by this to bring a lawsuit to say, hey, Los Angeles, I think you need to change your culture. There's some systemic things that you could change. There was no way to do that. And so Congress essentially passed a law, and I'm going to just refer to this law as pattern or practice authority, and that allowed the United States Attorney General to do just that, to investigate a police department and say, look, we think that there's some systemic things going on. What might these systemic things be? They might look like racial profiling. It might look like excessive uses of force. It might look like you don't have a really good complaint process. If there's citizens that want to complain, how do they do that? And it might also look like you have a number of officers, and there are reports, I can think about Chicago, where 5% of the officers within your police department are responsible for 95% of the abuse allegations or the complaints. So if we can identify this small group of folks, instead of promoting them, instead of letting them supervise other people, if we can identify them and either fire them, discipline them, retrain them, then maybe we can do something about the culture and the pattern or practice of abuses within the police department. So the United States Attorney had this within their authority to do, and this was under the Clinton administration. There were a few consent decrees, a few lawsuits that were brought that resulted in consent decrees. Well, what happened when President George W. Bush took office? He was took a hands-off approach and said, well, we don't really want to go in suing these police departments to usher in this systemic change, but we will allow some of these police departments, like Washington, D.C., and I happen to be, for a brief time, on the independent monitoring team for the agreement that the Washington, D.C. Police Department reached with the U.S. Justice Department. And these police departments will they invited DOJ in under the Bush administration sometimes, and they can't cobble together this agreement that said, well, we'll address the racial profiling, the complaint process, the early warning tracking. We'll have something to address this. And so this kind of went on for a few years, and I thought was not the greatest way to address police accountability within some of these local police departments, but a pretty pretty good start when we couldn't, as we've talked before, when we couldn't really trust the states and cities to do this for themselves, because if you take a look at certain police departments, the corruption and that was so deep, and the culture was so compromised that they could not be trusted to usher in these reforms by themselves. So what happened then when we get to the Obama administration? The Obama administration brings a couple of dozen of these lawsuits and investigations, and it's very active. The reason I think that this federal, the federal intervention was important here is not that they could reach, there were some flaws with it. They couldn't reach a ton of all of the 18,000 local police departments. They couldn't reach everyone, but they could put up some pretty bad actors and say, look, if you have these types of things going on in your police department, we might come looking for you, or at least if something like this is going on, here's a way in which you might be able to fix it. And so that happened under the Obama administration. Well, what do you think has happened since 2016? So Jeff Sessions actively, if President Bush was like, well, I don't think we should have the federal government involved in these local communities. Okay, that was President Bush. That was, that is a stance you would expect a state rights person to take. Jeff Sessions flies into Chicago and tries to persuade the actors there that no way should you allow, I'm the Attorney General and you should not allow us to help you with your police misconduct in Chicago, of all places. And which, again, there are lots of specific instances. So I say all of that and give you all of that history to say that we're at a different space and time now when we're thinking about police accountability, and we've seen the limitations of this type of federal intervention. We're not going to be able, at least for the next the time being, to rely on the federal government's intervention. And by the way, how effective was this anyway? If you can only reach, I don't know, maybe 40 or 50 police departments out of the 18,000 local police departments. So it's going to have to come from the local government. There's a role for state AGs, which I can talk about later, maybe during the Q&A, but localities have an extreme amount of power here because, and we've seen it when you can elect, when you have an electorate that can elect a quote, air quotes, progressive DA who's actually going to prosecute police officers when the conduct rises to an appropriate level to be criminally prosecuted. You can also see the impact in my own state of North Carolina, Greensboro, a little city in Greensboro. Actually, they don't enforce seatbelt laws anymore, okay? So that seems like kind of an innocuous thing, but that's exactly how the racial profiling in Greensboro was manifesting itself, that officers would be able, for this violation, they could stop anyone in the world, but they were stopping black motorists at a vastly disproportionate rate. And so a local change, because once you have the transparency around the practice, the electorate would not stand for it. Your mayor is going to appoint, if you're elected mayor, the mayor's going to appoint the police chief, and the police chief then has got to look and say, well, what changes can I make or should I make? So I just say all that to say that that the local communities and what we've seen in terms of the activism at the local level has really ushered in a number of concrete changes.
Yeah, terrific stuff here. If you want to change criminal justice, go work for a progressive DA, right? The Philadelphia DA was here recently to speak to students here, and that's where you get the work done. And he was a defense attorney, right? Criminal defense attorney. Well, that's where it's not going to be, right? The Attorney General of the United States swooping in. That's unreliable, as you point out. The other thing is sanctuary cities, right? this goes to the workarounds issue, which is local government has a lot of power to enforce or not to enforce, to make stops or not to make stops. There's limits to what the federal government can force them to do under our federalism jurisprudence. Again, these should be avenues that progressives don't think of as second best. They should think of them as first best, it seems to me. And so one question for the panel is, how do we get progressives to not to get rid of their suspicion of localities, and states, although I think that's part of what's going on here, but also to more directly think of these places as opportunities, as opposed to a second best solution, and particularly to stop having so much faith. If we just win the next national election, it will all be all right. And I think that's a big danger that progressives have bought into for a long time. But I want to open this up. That's a question on the table for all of you. I do want to open this up because we want to get questions from the audience too. So I think there's some folks out here with hands raised. We have microphones. Yep, there he goes.
Hi, I had a question about, so I'm at Vanderbilt University in Tennessee, and I think that we have, our urban areas like Memphis and Nashville have come up with really creative and progressive ideas. Nashville recently voted in a referendum to create a community oversight board over the police. And what we're running into is state preemption. And so we're getting, the city passes something progressive, and then conservatives go to the state legislature, they preempt it. And so are there any strategies around how to deal with that, especially in our case, Republicans have a supermajority in the legislature, so how do we deal with something like that?
Yeah, so on the panel, have you run into state preemption similarly, and what you have any responses to it or thoughts?
I mean, it's an issue in my state as well, North Carolina. I mean, I don't know if I have solutions. I think it is an issue that I think amplifies the power of states as, they are, the state government, under the federal system is supposed to be the kind of default repository of power, right? And a lot of that is directed to the state government. And it's not to say that localities aren't also important and that we shouldn't be supporting progressive local action, but in a lot of areas, you're right that under state constitutions, under the federal constitution, that it's really the state government that is the ultimate authority. And so just, emphasize the point again that that's an important place to contest.
Yeah, I guess the only thing I'd add is, preemption is certainly an issue where municipalities are creatures of the state, and states can give and take away powers as they see fit. Sometimes preemption, contra idea of home rule is embodied in the state constitution. Sometimes it's in statute. And so it may depend on the context about how difficult it's going to be to reverse whatever you're seeing in Tennessee. And I don't know the specifics, but I think it all comes back to redistricting, unfortunately, which is, I brought it up in the context of who gets to determine what the state's legal interests are, but so many of these issues are determined by state legislators, and unless we, as a society, get a handle on redistricting, then a lot of progress can't take place, because then those things wouldn't have been put in statute. There is a way. I don't know what the referendum process is in Tennessee, or how you get things on the ballot to change state constitution, if that's where this preemption idea lives. But that is a more grassroots way that you might be able to change the dynamics.
Unless you're unlike Virginia, where our constitutional process is just bizarre.
And then it's a slower process. What Trevor just said broke my heart, and the reason for that is because he said localities are instrumentalities of their states, and that is the standard statement of constitutional status. But being a person who writes about cities and city power, it doesn't have to be that way. That's a doctrinal move. And we have had movements in this country when states were taking over city police departments or eliminating the mayor of a city and replacing them with their mayor this is at the turn of the century and the early part of the 20th century. We had a home rule movement. And one of the things that I think is necessary now, as we see a lot of red state, blue state tensions and conflicts, which have erupted in part because cities like Nashville are much more progressive than they used to be, and the preferences of those citizens are much different from the preferences of the legislature as a whole, in part because of gerrymandering. That has to be fixed, certainly. There is an anti-urban bias in states and across the nation, right? We have rural states that get much more representation, for example, in the U.S. Senate. This is a big problem for cities. And so the one question would be whether there can be a nationwide, and it's hard to get people excited about this, but a nationwide home rule movement that is similar to the home rule movement of the early part of the 20th century, which was to say, hey, hands off the cities. That's important, and I think, again, important for progressives to start thinking specifically about what is this preemption explosion that has happened in the states. And it's not just policing or civil rights legislation, it's environmental law, it's minimum wage, it's sugary soft drink taxes, it's plastic bag bans, it's fracking, it's basically anything you can think of that the state doesn't like. They have overridden, and we don't have quite the institutional and legal tools yet in the states to combat that, but it needs to be very high on the agenda, I think, of progressive organizations, because I think if you want any kind of any progressive legislation, it's going to come from cities in a lot of cases. Other questions?
Hi, good afternoon. This question is for Mr. Park and Mr. Cox. Given the typical interest areas of an AG's office outside of the Medicaid and housing context, where do you see room for the AG to increase litigation under the FCA statute?
Outside of housing and Medicaid? Ryan, you want to take this one? Instead of phone a friend, maybe you can give 4 answers and then we take the 50-50. And then
You can pick number 3.
If you have ideas. I don't have personal familiarity with that area of law, unfortunately. Yeah.
You guys are a disappointment. That's what.
Boy,
They're gonna go back to their offices and get on this right away.
After law, it just shows that after law school you can forget like everything about your area.
Well, can I?
Yeah, go ahead.
So I had one idea that I thought of while Trevor was speaking about what to do on preemption, and this is kind of just a more general idea that applies broadly to a lot of issues that we're talking about today, which is that we shouldn't forget about state courts, and that when you want to, for example, if you were to reevaluate this question of state preemption law in Tennessee, the body that would do that would probably be the Tennessee Supreme Court. It wouldn't be a federal court necessarily, and that as with the general welcome attention to local politics in this era, I think with the federal court system as it is currently composed, I think it's welcome that a lot of progressives are also paying attention to state courts and seeing this as an area where local law can flourish and develop in ways that might deviate from how the federal courts are applying the federal Constitution.
Yeah, and state constitutions too. State constitutions are easier to amend. There's some risks to that, but they're easier to amend than the federal Constitution, and we have tended to amend them quite regularly historically, and that's a place you can make some real change. Saw some other hands, one in the back.
Hi. So I guess to me, the idea of zoning first came up in property, and I've noticed it more and more as like a dangerous kind of sleeper cell issue, especially in the realm of criminal justice, abortion, election law. And I know this is kind of a radical idea, but not one that's too far from memory, but is there something within the realm of your kind of jurisprudence where you could say realistically, like, could we get rid of zoning, limit the extent of zoning laws within those issues? Because I mean, I think in a lot of ways, I know in abortion specifically, zoning has become the #1 tool to kind of reduce access, and same with in criminal justice, or not so much in criminal justice, but in housing and in election reform. It's huge. So I just wonder, like, what can we do to limit the power of zoning laws so that when it comes down to that issue, they can't just kind of, you know, these local municipalities can't just zone away our constitutional rights while no one's watching.
Well, I don't know about getting rid of zoning, but one thing that we as advocates can do, and did do in Manassas, Virginia, where that particular zoning was didn't go through, was shine a light on those very local issues and be very vigilant, right? Like, and that's partly why we are the experts-ish in our areas. And that's part of our role as advocates, is to keep an eye out on those things. Because we know that that's an area where we have to look at really closely. We are constantly looking at what is going on with the local municipalities and zoning. Within the Virginia, how like Virginia government works, I don't think there's any way we can detooth zoning ordinances, right? Like we can't get rid of them, unfortunately. But what we can do, and what is sort of the nice thing about hyper-local governments, is when you shine a light and when you get a lot of activists, you can really pack a room. And you can really drive that narrative. And more often than not, those local governments are not prepared for that kind of activism. They think they can just do things in the shadows and nobody will notice. And if you suddenly go, no, this is what's going on, they don't necessarily always cave, but you can really apply a lot more pressure than you can necessarily on like the state legislature when they don't always care what the popular opinion is.
Yeah, this is another good point, which is the local is responsive. These are part-time legislatures. They're community members if there's a lot of noise in the room. And what's nice about the question is, hey, look at this. Land use, which I didn't think was a constitutional issue, suddenly has all these implications. The other thing, I guess, to say about that, which is a nice point too, which is local and state legislatures are often part-time. They don't have big staffs. They don't have a lot of expertise. And they're easily overwhelmed by, say, corporate interests who come in, and ALEC is one of these organizations that comes in and gives them model legislation. And they're doing it at the state level everywhere and at the local level. If progressives were to provide alternative resources, then they could give certainly resources to progressive legislators, but also to just your run-of-the-mill legislator who's not that necessarily that political, who's just taking what's been given to them off the shelf. So I think there's a lot of room for organizations and research and assistance, and this is where students come in a lot, to support those levels of government with just expertise. That's important.
And I kind of, not for myself personally, I have no desire to run for local office. But this is where I really do put a plug in for being involved in the local community. And as we were saying, whichever justice it said, go back to your community from law school, I think in general as a society are so focused on the state and national issues without even thinking about how the local issues affect you on so much. It's the local school board that's choosing whether your children gets the book that identifies slavery as indentured servitude, as the ones in Texas do, right? I'd like to think that as the progressive community gets more involved in and recognizes the power of the local government, more progressives will be running and involving themselves in the local government. It's not obviously the same, but Emily's list was saying that they had, for the entire 2020 cycle, they've gotten 900 women who'd wanted to run for office. Or before, basically, pre-DT and post-DT. But that post the 2016 election, they got 40,000 women who wanted to run. And when I say office, I'm not saying senator. I'm saying local school board or city council where it's a part-time job. So I think as we move more, as progressives recognize that the local, that we have other avenues to really get involved in local government.
Do we have time for one more, maybe? One more question? Got one here. Yeah, last one.
Hi, thank you all for coming today. With respect to federalism all the way down, we've seen the federal government tend to protect state rights and state right to self-organize and self-govern. This seems analogous to state courts and cities' right to self-govern. And you mentioned, Professor Schragger, that was largely a doctrinal issue, why state self-governance gets protection, but city self-governance does not. So I was wondering, what do you think is necessary to switch that from a doctrinal issue to protections that are implemented in the real world?
You question.
I think that's for you.
You're all experts. I'm the moderator. What's going on here? So you have to there's a couple of the distinction obviously between states and cities is states are recognized in the Constitution and they have sovereignty. How much we think they should have dignity, as Justice Kennedy famously wrote about, is puzzling to me. I've written that states are not actually fulfilling a lot of the values or principles of federalism. That's actually being done at a more local level, at the city level, and that states, in fact, seem to be converging in lots of ways. California is an exception, but a lot of states are converging on kind of a deregulatory agenda of a certain kind that mimics just the national agenda of, say, the Republican Party, for example. But there are right now there's some constitutional doctrine that seems to suggest but is old that. Local governments, as for constitutional purposes, are just convenient administrative agencies of their states, and so states have plenary authority over them. As I said before, you can operate on the internal state-local constitution, and we do have home rule grants in lots of states, not in Virginia. We're a Dillon's rule state, which means we don't, in fact, have that home rule sphere. But even in home rule states, state legislatures are usually able to preempt, as we said before, local legislation at will. There's some exceptions to that. So you need changes in those doctrines at the state court level in most cases, because I don't think you're going to get it from the Supreme Court. There is an old theoretical and doctrinal arena in the beginning of the 20th century that did recognize a right to local self-government. And so it did grant a certain level of rights to local government, not just to state government. That has been dispensed with mostly, right, at the federal constitutional level. So I think most of the action, if there is some, it has to take place within the state, and it has to be in reforming and pushing on the state home rule grants that are there, but also demanding that state legislatures retract preemptive legislation and also grant localities, which they can do, powers that they're not willing to grant them now. So you can have progressive state legislatures, and this is why elections matter. You can have them entrench protections for local government. They often aren't willing to do that because they're nervous about what happens to that local government if political power changes there. But this is, again, another lesson for progressives. It seems to me sometimes you want to entrench power at the lower level, even if it might be used against you in a particular policy, because I think the long run benefits of that are higher than the short term risks. And again, progressives have not been quite willing to do that. What progressives have done is gone issue by issue and said, where do we get the best deal? Everybody does that. If we can get gun control at the state level, great. If we can get gun control in Congress, great. If we can get it at the local level, great. But I think what that means is you're going to get preemptive legislation at the state level, and then your gun control at the local level is never going to happen. And I think, again, I've said this before, the best place to get this stuff politically, and I think for a long time going forward, is in our cities, which are just by their nature often more progressive because of sorting and all these other features. So there isn't an easy doctrinal answer, but there are ways to kind of move this ball, and it's mostly through politics.
One final thing I would add to that is that we've been talking about it as if it's a zero-sum game, and it may be in most aspects, but there is opportunity for shared responsibility, shared power. I know in California it's not exactly the False Claims Act, but Deceptive Unfair Practices Act. I think the California has given city attorneys the ability to bring actions under that statute. So it's shared with the AG. The AG can bring action. The city attorneys can do it. Maybe it's just a certain category of cities, a certain size or a certain jurisdiction that can do it. But there is an opportunity for shared.
And San Francisco has used that authority quite dramatically and effectively in bringing lawsuits.
Data privacy, automakers, some of those kinds of issues.
Yeah, and so this is not directly related to that issue, but I noticed, we're talking a lot about cities and what cities can do. And so for my particular area of concern and with regards to police accountability, cities can be are very important. But when I kind of look at the map of our country and you kind of look at the more progressive cities and where things are happening, they are happening in Philadelphia, and there are new things coming out, new reforms coming out of Chicago and larger jurisdictions. But the same problem that we saw with the federal legislation is that you're going to get the attention is going to go to these larger police departments that impact a lot of citizens. And so what that leaves is a lot of rural communities and communities outside and police departments and law enforcement agencies outside of big cities that are still suffering. So even though, we were talking about progressive federalism, again, it's just that the importance that the role that the federal government can and probably should be playing in some of those areas. And I just wanted to go back to one thing that I mentioned earlier was the state AGs. That federal legislation that I talked about. So it's still there. It's not necessarily going away or being repealed. But imagine if you had, instead of one attorney general, you had 50 attorney generals that had analogous state legislation and could work that way with police departments.
So thank you all. Terrific panel. Join me in thanking these.